Welcome back to Law Unpacked. I'm your host, Attorney Shawn, and today we're exploring an important topic for anyone emerging from bankruptcy: how to review and correct your credit report and ensure your rights are protected. Joining me is Kyle Schumacher from Schumacher Lane, an attorney with deep experience in bankruptcy and consumer advocacy. Kyle, we're excited to have you here with us.
Shawn, I'm glad I could be here speaking with you.
So, Kyle, tell us, how did you get into the consumer advocacy part?
Well, I started practicing law 13 years ago, and the very first job I had was with a bankruptcy attorney. One attorney, his wife was the office manager, and they had one other paralegal, and they would crush bankruptcies, do 30 to 40 a month. And I was like, whoa, this is wild. So we were doing that. As I was doing that, I'd have clients who completed their bankruptcy and started asking me, hey, what do I do about my credit report? Or what do I do about this creditor still calling me? And I'd ask that attorney, and he'd go, hey, we're not worried about that. Tell him it's discharged. And so I go, well, it's discharged. And I started looking into it, and I said, well, there's some laws that protect you here, and started filing lawsuits. And when these people, when the clients would come up and tell me that, I go, oh, maybe I could file a lawsuit here. And that attorney ended up being pretty happy that I did that because I made him some money.
Yeah, so let's dive into that a little bit further. You say you're filing lawsuits if there's stuff on a credit report after bankruptcy. Tell me more about that.
Yeah, well, so the way I'll go back a little bit more into history. The way that I started it was I had a client who said, hey, this one company is a tanning booth company. They won't not let me be a member anymore. They keep telling me that I'm a member. And I said, no, I filed bankruptcy. I notified you guys, and I don't want to be a member, and I don't want to pay it. And I said, well, that sounds like it's a violation of the automatic stay of the bankruptcy code. And so I sent a cease and desist letter, strongly worded letter saying stop. And they didn't. And I was like, all right, well, I guess I'll file my first lawsuit. And that was about 6 or 7 months into practicing because I'd just been filing bankruptcies. And did that. And they settled, paid my client basically the amount that she initially paid to file bankruptcy. So she got away with that. And one of the deals was clear it off her credit report as well, that they wouldn't report it there. So then I started thinking, well, wait a second, how often is this happening? And so then I started talking to clients. I just said, hey, go look at your credit report and let me know if somebody's, reporting something different that shouldn't be there. And then there was enough people doing that I just told every client, I said, once you get your discharge, I'm going to review your credit report and I'll let you know. You tell me if you see something in error, but lots of times I can see what the legal ramifications are. So we'd go, all right, here's the error. We're going to write a dispute letter, and that generally fixes it. But honestly, 40% of the time we find an error on someone's credit report that we're sending a letter to fix.
I mean, that's a lot of percentage of people that you're reviewing that you find an error. That seems higher than normal. Is that accurate? Really, 40%?
We are, I think, on average, in just if people who haven't just completed a bankruptcy filing, they're going to have 20 to 25% errors on their credit report. So because of the unique change in getting a discharge that happens, that's why I think there's the increase with people who have a discharge.
So going back to that first, so you're saying that you said, hey, you can't have this on your credit report anymore. The tanning salon company came back and said, well, we're going to still keep going. And now you're able to bring a suit against them to get them to remove that.
Right. So so in that instance, the condition of the settlement agreement was I said, hey, we don't want you to report on the credit report anymore. And they kept doing that. And so that brought another violation. But the way that it often happens in bankruptcy is, let's say that somebody does a reaffirmation agreement. That's actually where a big one happens. I'm assuming that a lot of your audience would know what a reaffirmation agreement is. Can I assume
That's a
that?
great question. I mean, why don't you explain what is a reaffirmation agreement for those that may not are first time listeners or don't know what that is?
Okay, so you're doing a Chapter 7 and you have a vehicle that you like and want to keep and it has a loan against it. So when you file, you indicate your intent to keep the vehicle, continue to make the payment, and there's a document called a reaffirmation agreement that gets signed between you and the lender that says, I'm going to keep the vehicle, I'm going to continue to make payments, I'm going to continue to be liable for it. And if you continue to have that personal liability, then one of the things that a creditor does is report your ongoing payments to the credit bureaus. And so that's what you would want. That's one of the reasons to keep it, because that's going to help you build that credit. That's an installment type of loan that helps you build the credit. Well, you get your discharge, and lots of times the company reports it as discharge in bankruptcy instead of reporting that was reaffirmed. And so we'll send a letter and saying, hey, we actually reaffirmed this. So we'll send it to the three bureaus and say, this debt's actually reaffirmed. Our client's making the payments, and here's the proof of those payments. Please correct this. Well, what the bureaus do, they're required, the law says, okay, we got to send it to the data furnisher. Who's this creditor? You guys tell us, are they actually making these payments? And again, that's why there's an uptick, because you're dealing with reaffirmation agreements and debts that the creditors aren't properly paying attention to, of whether they're going to continue through a bankruptcy or if they're going to be discharged from the bankruptcy. And that's why there's the uptick. Well, we send the dispute, and lots of times that gets corrected. And as a matter of fact, one of the great, we're always trying to, when I first started to do this, I didn't have the numbers. Now I see it more and more, but I had a client earlier this year. He had a dispute that for this reaffirmation. We send out the dispute, they correct it, which was great. So there was no lawsuit involved. It took 45 days to get it corrected, longer than you'd want, but it took 45 days. And his score went from 570. I wrote it down here because I didn't want it to remember. It went from 498 to 584. So he got an 86 point increase. That was the only change on his credit report, was that just reporting instead of discharge and bankruptcy, reaffirm and current payments. And that's how big of a deal this can be. So if they don't correct it, that's when we would bring a lawsuit and we file it in federal district court.
So what happens if, let's, staying on this reaffirmation agreement, what happens to all those previous payments? Let's say they were missing payments prior to filing bankruptcy. Does that stay on their credit report, or does that go off and come back once the reaffirmation, or does it not go back at all? How does that really play into it?
So if the information is accurate and it's passed, then it can stay on the credit report. So you can't remove accurate information. So things that we can dispute and get removed is something that's inaccurate. So lots of times somebody who does a reaffirmation agreement has been consistent in making their payments. And so there's not going to be a problem with that. But even still, it's better to keep that installment loan going, right? And especially if you got it current and caught back up, because the further you get away from a missed payment, the less it's going to impact your score, right? So if you can get back onto, I filed my bankruptcy, I did a reaffirmation agreement, and I'm current, and you keep making those payments, that's going to be better for you, again, because it's that installment loan. So the biggest thing in order to improve your credit, there's three things to do, all right? The first thing is you got to correct the errors, right? You get your discharge, you immediately correct the errors that are on your credit report, right? You do this by reviewing your credit report. You got the discharge, and you compare, go, what is accurate on here, what needs to be changed. Then you have to write certified letters and send it to the bureaus to get that done. This is literally the hardest part to do, and that's what my firm will do for folks who've got their discharge. The second thing is you want to get 3 credit cards that are revolving, right? You can get 3 credit cards that will report, and you'll do that. And the third thing you do is get an installment loan. And so that's where the reaffirmation agreement can come in handy if you're doing that to keep that vehicle, and that's an installment loan. I do know that you had Ash Auto Group on, I can't remember how long ago that was, but so if you get a car after filing, that will be an installment loan as well. So you want to do those 3 things to help your credit, but the biggest thing is make sure that the errors come off. And so when you do that, and you remove, like I said, the error in that particular instance that I was reading about was a reaffirmation, discharge, instead of reaffirm, paid, current, ready to go. Now, we file a lot of cases that way too, where they don't get them corrected. And the thing is, if you're not looking to get your your credit report reviewed right after discharge, lots of times people don't find out that they have an error on their credit report until they actually go and apply for credit. And
So,
then
I mean, that brings up a good point. So what should your credit report look like after you get your discharge?
Yeah. So there's the things are called trade lines, and that's every individual account that you have is going to report. So if you have Bank of America and Wells Fargo, they'll each have their own individual trade line. And if you owed a debt to them, like a credit card, then you would want it to say discharged in bankruptcy. But there's times where it doesn't say that. Let's say that it's a credit card and it was discharged. There's times where it says that there's a balance of $5,000 or $10,000. Well, that's going to
So hang
be
on, but before we get into what it should say, so what you're saying is that every debt that you had that was any debt, frankly, should list as discharged if it was discharged in the bankruptcy on your credit report. Is that accurate?
that's correct.
Okay. And so what happens then? Okay, so let's say it doesn't say discharge. Now you're going into saying, what happens if it doesn't?
Correct. So, and then if it doesn't, so now we're looking at it and we're going to compare and see why it might not say that it's not discharged in bankruptcy. And when it's these credit cards, right, there's actually been judges who have ruled and case law that's put into place that says, you know what, Experian, TransUnion, Equifax, you should actually know that this debt was discharged. And so they're almost in trouble from the get-go, even before we write a letter. We always write a letter, though. We always help you do that. And the reason we do is because judges love it, which is great because they want people to have notice. Judges don't like it when they feel like a creditor is being surprised. So we're writing letters left and right. We're giving them all the documentation from your credit report or from your bankruptcy to support what we're saying is the inaccuracy in your credit report.
So just so I can tell our viewers or make sure our viewers are following along. So first they file the bankruptcy, then they're going to get a discharge about 90 days later. Once that discharge happens on their credit report, everything that's been discharged should list that it's been discharged in the bankruptcy.
That's right.
Now, sometimes it doesn't say discharge. It keeps as whatever the balance is, or what are some of those, what are those common errors that you see on those credit reports?
Right. It is mainly that there's going to be a balance showing. So there's a couple of different sections. There's a balance showing, or it could show instead of discharge, it in the section where it's going to say discharge in bankruptcy, it's not going to reflect that, and it'll say late. Or another thing is because you have the payment history section, and the payment history section, which is right below the trade line, it'll start to report, past due month after month after month after you filed, after you got the discharge in your bankruptcy, right? So that's going to be another error because that's a more recent missed payment. And as I was saying earlier, when you have a missed payment, it's going to hurt you. But the further it goes back in time, the less it's going to hurt you. So if a creditor continues to report that after your discharge, you'll just never be able to get above water, and that's why you need to file, send the dispute to get that corrected. And so sometimes we'll send a dispute letter to correct things, and we'll often find multiple things on a credit report that is related to credit cards, debt collectors. And here's another tricky one: is often medical debt is not reported on a credit report, and now there's new laws on when they can actually place it on there. And so sometimes it takes a long time for a debt collector to finally appear on a credit report, and that debt was actually discharged in the bankruptcy, and they're just reporting it, and they're going, well, we got the debt. It was passed on to us after the debt was discharged. So we had no idea. We looked at that there was a bankruptcy, but it was passed to us after that. Now, they're not doing their due diligence. They need to go, when was it incurred? But that is one of the things that happens. And so you do have to be pretty vigilant in making sure that your credit stays clear. Otherwise, again, you go to apply for credit, you get denied, and you're going, what happened? And of course, they're supposed to tell you when you do get denied, they need to tell you, what report was being used and what on that report was the reason for the denial.
So how soon after somebody gets their discharge should they look at a credit report or could look at their credit report?
Well, I would do the day after. That's what I always say. Give me one that's the day after, because sometimes, the bureaus will go, well, look, if you wait, we can't even update it that quickly. And I go, well, okay, maybe you can't. But if you get it to me the day after, then we'll dispute all of the things that they end up eventually updating, and we might find some things that they weren't going to update anyway, and it gets corrected sooner. And so let's say that you wait 30 days so that the bureaus have time to make those corrections. Well, now you've waited 30 days to find the error that they weren't going to get corrected anyway. So that's why I like to do it as soon as possible after you've gotten your discharge.
And where would a consumer best find their credit report? Should they pay for it, or are there free sites that they can go to look at? What do you recommend with regards to getting their credit report?
There are two sites that we often get the reports from. There's annualcreditreport.com. That is free. And I don't remember what all the regulations are right now because they were changed a lot during COVID. So at one point, you could get a new report like every week and didn't have to pay for it. But annualcreditreport.com has a lot of good information to see what's on your report, what people are reporting, and then who's looking at your report, who's requesting the bureaus what they're going to look at. And so that's what we use a lot. And then we also use the Experian Tri-Bureau report because it has all three reports on there. And that one, you can often do a free trial, check it out for a week or two, and pull your reports, and you get it for free. If you cancel it before the week or two is up, then you didn't have to pay anything. If you don't cancel it, I think it's a $20 charge, which often is worth it if you're if you're getting your credit report and finding the errors and getting them corrected.
And then you mentioned that debt that gets placed on afterwards that was pre-dischargeable debt or
Yeah.
debt prior to the discharge. How often should you be continuously monitoring your credit report after the discharge?
Yeah, I think that a good habit to get into is to do it about every 6 months. I mean, you could do it quarterly or every 6 months, right? Something to that effect. And some people just get the updates to go, hey, there's a change in your credit. There's something going on here. And especially if you know that you're going to go and be applying for something, maybe you're going to get furniture, maybe you're buying a vehicle, or maybe you just want to get, a credit card that has airline points. If you know you're about to do that, you're going to want to check on those things. So if you're keeping up on it every 3 to 6 months, then you're going to see those changes and be ready to apply when it's time, as opposed to going, I wanted to apply and now I can't because there's this thing on my credit that's going to, if you get denied, then that dings you, your credit score goes down, and you don't want that to happen.
And so once that happens, so let's say they find a dispute. So step one is they send a dispute letter to the credit bureaus or to the.
Yep.
And I understand this is something that your office would do for them, but walk us through that.
Yeah. So if you're going to do it, but this is what we would do. You find the error and you're going to send a dispute letter, and each bureau has their own specific address where you can mail it to. And I like to mail it because I can keep track of it, right? You can send it certified mail and you can keep track of whether they receive it or not. And it's outside of their internal system. And so it's within your control, and you can see, okay, did they get it? When did they get the letter? And then you give them the time. And we give them 45 days to make sure that all of the changes actually occur. Once that happens, you're going to go pull your credit report. And you don't want to pull it sooner than what the law allows, because if it doesn't change, it doesn't matter. You have to give them technically 30 days from when they received the letter. But that's why I give them a little bit extra time, just in case they go, well, we didn't really receive the letter until this date. I don't want to have to deal with that argument later on. So I just give them a little bit of a grace period. Well, then you check it. And if it's correct, if it's corrected, that's great. Here's another interesting thing. If they don't, sometimes they'll change it, but it's not correct. And then you have to look and this is where we come in and make a legal determination. Sometimes they change it and but it's not corrected. And then we look at what our letter says. And we say, okay, was our letter sufficient enough to put them on notice that this was the correct information? And so although they removed this inaccurate information, they either left inaccurate information or they put new inaccurate information on there. And so that's where it's often helpful to have an attorney, because at that point you go, well, what do I do again? Do I have to write another letter? Sometimes you do, and it will do that. Lots of times it is, no, they should have known. They know this type of dispute happens regularly. We sent them the proof of, let's say, that payments were being made on a specific month, and they're going, no, we're not going to correct that. Or they're going to correct and say that it happened on a different month. Then we might still just bring a lawsuit right at that point. And that's in order to basically force them to come to the table and say, are we going to get this credit report corrected or not when you file the lawsuit?
So assuming they don't respond in 45 days or not to what they should do under the law, at that point, you're looking to file a lawsuit. Is that accurate?
That's right. You're right. And so we'll look at, depending on all three bureaus, did all three of them keep it inaccurate? Was there 2 out of 3? Was there 1 out of 3? And then is it possible that the creditor is sending incorrect information? And it's all those possibilities, right? We'll end up filing lawsuits, and then the creditor go, well, actually, look, this is what we sent them, and this is correct. And then we go, all right, you got it wrong. Shame on you. And now, there's statutory penalties that are in play. I mean, the goal is to get your credit report corrected. When we file these lawsuits, that's the main goal. Sometimes, you'll get money in your pocket. That's always fun. But the main goal is you're getting it corrected so you can get to your next step of what you want to do. I want to get this car. I wanted to get furniture. We're about to have a baby, so we need a crib or something like that. And those are the things that most people care about, getting that corrected so they can just move on with their life.
Yeah, which brings up a great point. So you mentioned, are you filing suit against the creditor or are you filing suit against the bureaus? Or both?
Well, we often file both. And the reason we do that is because at the initial point, we often don't know who made the error. And so it could be that the bureau didn't correct it or that the creditor is sending the wrong information. And so we do try and do our best at the very beginning to investigate and figure out if we can figure out who it is that acted, did the wrong thing, we'll only list them. Sometimes you just can't figure that out and we have to list them both. And then what happens is one or the other will say, this is what we sent, this is what we did. And that gives us the evidence we need to basically show that, all right, Mr. Creditor, you actually sent the wrong information. You're the one that's at fault here. And we get it resolved. And these normally they settle out because, again, if you go all the way to do litigation, and sometimes people go to trial every now and then, but it's extremely rare because that takes years, right? But to do this and get the dispute process going, you're going to normally settle. And the problem is I've had people call me after, they try and represent themselves and they file it. And they normally just get brushed to the side by whoever they're dealing with because they're dealing with multi-billion-dollar corporations, right? Who are going to try and railroad them to get them to go away. And so that's why, I often recommend make sure you have an attorney that's going to represent you in court.
Well, we talked about, how they're supposed to correct things, but what laws are in place to protect consumers if their credit report is incorrect?
Yeah, the main one is going to be the Fair Credit Reporting Act. And so that's federal. And so it's applicable to all 50 states. And so that's the one that you're initially going to look at. And then often there are state-specific statutes that are in place that require creditors to comply with those state-specific laws. And sometimes they overlap. If they overlap, then it's the federal statute that's going to be in play.
Going forward, now, because it's a federal law, are you able to practice in all 50 states? Or tell us a little bit about your practice and I know you've done work here in Florida where I'm located at. I know you're barred in Texas. So tell our viewers and our listeners exactly, where you practice and where how you get those cases and or where to go.
Yeah, certainly. So we'll review credit reports from all across the nation. And then what often will happen is you and I have partnered on a case before, and you helped. You were local counsel for us, and you helped us pro hoc vice in. What that means is, oh shoot, this is how terrible that I am when I forget my Latin. But essentially, that means that a local court is going to allow somebody who's not local to practice in their court for that one specific case, and that's often what we'll do. And so I'm licensed specifically in Oregon, Texas, and California, and then in several district courts like in Indiana, some in Florida, and all across. And so since they're federal district court, there's different rules in that. But we often know attorneys in the state, and we'll, if your bankruptcy attorney is the one that sent you to us, we'll often work with that bankruptcy attorney to help us do the Pro Hoc Vice and represent them in that case. And then the other fun thing is that a lot of these companies are based in either California or Texas. And so you automatically have standing there to bring a case against them. And we often bring them in California or Texas. And there's a lot of companies in Oregon too. So between those, that's often where we're filing. And we can, as far as if you're in Maine or if you're in Hawaii, we can review your credit report and we'll find a place to make sure that you can file your case and get everything cleaned up and cleared up the way it needs to be.
So I know you partner with a lot of bankruptcy attorneys, my firm included, where you'll automatically review our clients' credit reports after bankruptcy. Let's say clients aren't working with one of those attorneys. How do they best, how would you go ahead and handle their credit report? Would you tell them to send it to you or call you once they found an error? What's the best method for that?
Well, yeah, they can certainly reach out to our law firm and do that. And our website, schumacherlane.com. And so if you just want to come to us directly and let us know that you have a particular issue, you can do that. One of the great things, as I was saying, there's three things to do to rebuild your credit that people are looking to do. And so the first one is you got to repair, you got to correct the errors on your credit. You got to get those 3 credit cards, and then you got to get an installment loan. And then there's I think you work with 7 Steps to 720. I love them. I often encourage my clients to use them as well. And if you go through their system,
Philip Tyrone, the creator of 7 Steps to a 720 Credit Score, was on a previous podcast. So if you're listening and want to hear that, please review that podcast that we did.
Yeah, so that is one area to get the rest of your score to go up. But yeah, you can come to us directly, go to our website, reach out, and we'll be able to review your credit reports. We'll tell you what you need to get. And another thing that I wanted to bring up about credit reports is not just the errors, but we do a privacy review. And this is related often to identity theft because, and we've represented some pretty egregious, the clients are great, but what's happening to them is pretty egregious. So, for example, we have a client whose identity was stolen. And it appears that his social and all of his other identifying information was sold on the web to someone, somehow. What that entity did, whoever did it, applied to dozens of apartment complexes across the country, dozens and dozens and dozens. All of a sudden, he's looking at his credit report going, what's this? And what's this? And what's this? And so then he is having to try and dispute with the bureaus. And these are real entities, these are real apartment complexes, but the actual entity that's applying, the person that's applying to be the lessor is not real, right? And I don't exactly understand the scam that was going on, but this came to us. And so then we're writing letters to the bureaus and we're writing letters to the different creditors. It goes to the debt collectors. And I mean, it just is miring to this person. And so one of the things that we do is a privacy review. And that's what I was saying, that annual credit report is great because you can see who's looking at your credit report and they have to tell you why they're doing it. And so sometimes there's very legitimate reasons, right? There's a section basically where it's advertising. It's called a soft inquiry, and you're gonna look at that section, and it's going to be towards the bottom of the credit report, and you'll see on this date, Discover Bank looked at your credit report, and that they can do it for a few different reasons. One of them is maybe they want to offer you credit, right? So did they look at your credit report and they would have asked the bureaus, they would have said, hey, we want to offer credit to certain people, and then they give their criteria, and maybe you fall within that criteria. They have the legal and absolute right to do that. And so we'll look at that, and go, okay. And then we ask, did they actually send you, do you remember getting something, let's say from Discover in the mail? And go, oh yeah, I actually did get an offer of credit. Other times though, there's a section where it's called account review. And it is, you already have an account with them, so you've given them permission to look at your account. And so let's say, again, we'll use Discover. You have a credit card with them. And let's say that the limit is $10,000. Well, they have the right to review your credit, and they'll do it through that soft inquiry. And one of the things that they'll review it for is, hey, are you making your other payments on time? And if you are, we notice that you're making our payments on time. Maybe they want to increase your credit score. Or not credit, sorry, your credit limit. Or they might look at it and go, you're not paying our bill on time very well, and let's see if you're paying other people's bill very well on time. No, you're not doing that either. Okay, we're not going to actually extend you any more credit, and the moment you get it down, we're going to reduce it, right? So that's another reason that they look at it. Well, after you file bankruptcy and you owed Discover $10,000, you file bankruptcy, you get your discharge. Now they're not allowed to look at it as an account review. They could look at your credit if they tell the bureau, hey, we're considering offering them credit again. They have the right to look at it, but they can't do it as an account review basis because they actually get more information. And you don't want your information getting out there because it's these huge companies that are always being hacked, which is where the information is coming from. So we will often look and review and see somebody you're looking at your credit report that they shouldn't be. And that's another thing. Then we'll write a letter. That if anything, I would be great in the 1800s because I'm so good at writing letters now. But that's what attorneys do, right? So we write these
lost
letters.
art, right?
It's a lost art. That's exactly it. We write these strongly worded letters, and we'll just say, hey, you look like you looked at our client's credit report. Why'd you do it? And please make sure you give us the permissible purpose pursuant to the Fair Credit Reporting Act, right? Do that. And we'll get letters back saying, okay, here's the reason. This is why we did it. This is what's going on. And other times they don't have a permissible purpose. And that's another lawsuit. And we bring that because we don't want people's credits to continue to be basically looked at. It's going, yeah, at one point I let you into my house to have dinner, but I didn't say, hey, you can always come and watch me eat dinner, Discover Bank. Okay. Sorry, I have anything going against Discover right now. So that's what I was thinking. They're fine. They've never come in and watched me eat dinner as far as I know.
Why don't you tell us about some of the successes that you've had with clients that you've seen some errors on their credit reports and you've gone ahead and got those corrected?
Yeah, certainly. It reminds me, because you had asked earlier, how often should you look at your credit report? And I said, every 3 to 6 months. We had a client a couple of years back who came to us and he goes, I have a credit report being reported on my credit report. And we go, okay, well, when did you file bankruptcy? And he said, I've never done that. And he goes, I have no idea what this is. And so we started looking into it and come to find out he had a business partner who filed an involuntary bankruptcy against him, was inaccurate. He never actually filed it. And so we had to start gathering the documents, sending out the dispute letters.
And hang on, I want to make sure I'm hearing you correctly. You're saying somebody filed bankruptcy for somebody else?
That's 100% what I'm saying. He was as flabbergasted as can be. And then he starts looking at the documentation, looking through the bankruptcy petition, reflecting that it's inaccurate. He goes, that's not my information. Other than, they had the social security number, right? And so it was connected to that, but everything else was completely inaccurate, and he just didn't know about it. And it was essentially a disgruntled, business partner. And I think what part of the reason is he was trying to file bankruptcy himself, and there's some technicalities when you're trying to do that and you own a business with somebody else. And so he goes, well, it's just easier if we both file, right? And so that's what ended up happening. And so we had to get the dispute. And so we sent all this information in, who he is, where he's lived, that he didn't live in the state that it was filed at the time that it was being filed. We send all that stuff. They don't correct it. And we were very diligent in writing this. And he had already sent a bunch of information to them, right? And it was finally he reached out to us going, I don't know what to do. I thought it would be pretty simple when I said that it wasn't me, but they don't believe me. So we did this. And we sent all those disputes. They didn't correct it. So then we filed a lawsuit. And what was great is that actually settled it real quick. It brought him to the table, and within about 3 months, he'd been dealing with it for about 5 to 6 months at the time he came to us. 3 months after filing the lawsuit, we settled it. He got a settlement, and he was pretty happy with that in the sense of at least he got money in his pocket. But I always ask my clients, I go, well, would you rather have the money you got in your pocket or just have it never happen at all? And he's like, I just wish this never happened at all. And so that's where I go back to every 3 to 6 months, just check it out. And if it's inaccurate, go through that dispute process, because you don't want to wait 6 years and try and unwind something that's that big. But again, he was very happy to have that corrected once he found out. So that was one of them.
Man, that's a crazy story that somebody just filed bankruptcy on your behalf. That to me that shouldn't happen, and I'm sure that we can go on a whole different tangent on another day and discuss how that
Oh, yeah.
happened. But any other success stories you think our viewers should or listeners should be aware of?
Well, one of my favorites happened to be after one of the sweetest ladies, and she was in her 70s. She did the Chapter 13 bankruptcy, and at the time that she had filed, she had gotten behind on her mortgage. Okay, so she was using that to get caught up on a mortgage. Is very common in doing a Chapter 13. And after the 5 years, she got caught up. She actually got up pretty quickly and had been making regular ongoing payments since the beginning of her bankruptcy. Well, after you get your discharge, they're required to start reporting ongoing accurate payments again, and they wouldn't do it. So the mortgage company wouldn't report it, or say, well, she's making these payments, you still have it listed as discharge in bankruptcy. It wasn't discharged. She's making these payments. The bankruptcy case is over. And they just wouldn't do it. I sent letters. I sent different things throughout to the bureaus, to that particular mortgage company. And again, she would just talk about, she's like, I'm making tea right now. And I ended up talking to her a little bit longer because she was just so sweet. As an attorney, you're often very busy, but she would just tell me about the tea that she was making and her little puppies, which were whatever. She's very sweet. Obviously, I really
Puppies take
her.
it for everybody, right? I mean, you tell me
Right.
about your puppies, I'm going to sit on the phone
That's
a
what it
little
is.
longer.
She's like your grandma, right? I wanted to go there and be like, let's have cookies. This will be great. Okay. They want to correct it. We sent these disputes. And she ended up settling that case. I think that one, she got $30,000 in her pocket. That was great. No, I'm telling you the big ones. This is, it's kind of like when you see the injury lawyers or that type of thing. They always tell you your biggest ones. We do a lot of these. They're very small settlements. She got $30,000, which essentially was going to pay off the rest of her mortgage because, like I said, she's been paying on that for a lot of her life. So I'm very happy about that because she essentially got money to pay them off, and they were the ones that paid her to have to be able to do that. So I love that.
So obviously you deal with a lot of discharged debtors. What are some of those common misconceptions that they tell you about that? Hey, I wish I would have filed sooner because, or man, I always thought this would happen and it didn't happen. What are some of those misconceptions that you see or hear?
Yeah. The biggest one is, this is going to ruin my credit for 10 years. It's going to be on my credit report for 10 years. And although the fact of filing a bankruptcy can be reported there for 10 years, it doesn't ruin your credit for 10 years. You can have a credit score of 720 or better within 2 years. People within a year of being done with their bankruptcy are able to buy a house. Like I said, they're already, right after filing bankruptcy, can buy vehicles. And the reason that I said 720 is because that's the score you want to get in order to get the good interest rates, essentially. So if you do the things that I was saying before, first, get the errors off of your credit, right? Come to me, we'll help you get the errors off of your credit. And then 2, get 3 credit cards that are going to report regularly. And then the next one is 3, you're going to get an installment loan. And that's going to help you within 2 years, you're going to get up to 720. If you get up to 720 when you go to apply for a loan, whatever the regular rates are out there, you're going to get it. If you have regular income and you have that credit score, you're going to get it. And
so even though you've had a bankruptcy in the last 3 years, you're going to get the regular rate if you follow those steps.
If you follow those steps, you'll get the regular rate. And that's what people are really confused about. And even within a Chapter 13, because you're actually paying creditors back, your score by the time you're done is often up around 700. And then once you start doing the 3 steps that I just said, you can get it up past 720 and up into the 800s, which is totally feasible. You're going to get, because you're going to want to buy a house eventually. You might have to move and sell the house that you're in and buy another house, and you just don't want to have to be paying those high interest rates. You don't want to always getting car loans that are at 29%. You want to get them at what are they at, like 6 or 7% right now. It's not the best right now, but it's better than 15, 20, 25.
Sure. So, Kyle, is there anything else that you want our consumers to know that maybe we didn't go over yet?
Well, one of the things is I mentioned it at the very beginning. It's kind of like where I started the litigation process, which is creditors who are trying to collect on debts that are discharged in bankruptcy. And that is something, the discharge is going to last forever. So I've had clients 5, 6, 7 years afterwards go, this creditor is trying to collect on this debt. It was discharged from this bankruptcy, and they can't do that. That's called a violation of the discharge injunction. And we litigate that as well. So we'll bring it before a judge and we'll say, Judge, they're trying to collect on this debt. They know that it's discharged and we want you to hold them in contempt. And that helps to enforce your rights in that instance. And that's kind of where I started, right? Like I said, the first thing that happened is this gal comes to me going, this tanning company won't leave me alone. They keep on trying to collect on this debt and they won't let it go away. And I realized, okay, this still happens. And as an attorney, because I still do bankruptcy law as well, I still practice that. And I don't want to let my clients have to deal with that on their own. And so we do that for all clients. And we actually have a lot of firms across the country who come to us and we'll help them litigate that issue for their clients once they've got their discharge as well.
Oh, excellent. Well, Kyle, how do our viewers and listeners reach out to you if they have questions or if they want to send you their credit report? What's the easiest way for them to do that?
SchumacherLane.com, SchumacherLane.com. I got to spell my own last name out.
No worries. I got one of those tough names as well, so I get it.
Yep. Thanks so much.
Well, thanks for joining us on this episode. Your insights into credit report reviews and consumer protection after bankruptcy will undoubtedly help all of our listeners on their journey to financial recovery. To our listeners, thank you so much for tuning in to Law Unpacked. Until next time, stay informed, take control of your financial future. I'm Attorney Shawn. Take care.